This is 180/200 speed and accuracy class, and we're starting with legal straight matter. Ready? For the record, in this action for personal injuries, the complaint alleged that the Emil Rose Construction Company, while doing some construction work for the Smith Trailer Company upon property belonging to said Smith Trailer Company, caused an excavation to be so carelessly and negligently left open and unguarded that plaintiff, while lawfully on the premises, fell into said excavation and received injuries. The defendant answered denying the material allegations of the complaint. The cause was tried before a jury, and verdict and judgment were in favor of plaintiff for $60,000. The defendant appealed from the judgment. There was evidence of the following facts. In the course of the work in which defendant was engaged, it was necessary to make an excavation which involved breaking up concrete, cutting it off, and removing steel rods and all other material necessary in the excavation of the pit. Removal of the concrete was done by the Power Tools Company, a subcontractor of the defendant, and it had been completed several days before the accident occurred. In this work, the concrete was broken up, rods were cut, and the material was thrown out of the pit by hand and onto the ground, where it was picked up by hand and thrown into trucks to be hauled away. Defendant's contract was not complete. He still had to lower the pit to a uniform depth of 10 feet and line it with concrete. At the time of plaintiff's accident, there was in existence an excavation 33 feet by 11 feet, which was at ground level at the west end and graduated to a depth of 9 feet at the east end. Plaintiff was an employee of the Smith Trailer Company and had come to work about 4 p.m., while some of defendant's employees were still at the location. Plaintiff was working on the northerly side of the pit, about 10 feet distance therefrom, when he decided to walk past the pit on the north side to a washroom. As he proceeded, he stumbled on a steel rod or bar or rod 3 or 4 feet long, which was lying on the ground 4 or 5 feet north of the pit, about midway between easterly and westerly ends of the pit. His foot struck the bar, he lost his balance, and went forward into the pit. There was no barrier around it. No witness observed plaintiff's fall into the pit. Plaintiff had observed work on the pit for about a week, had looked into it, and knew how deep it was. He testified that he believed the rod was a reinforcement rod. It had ridges on it. It was 3 or 4 feet long and maybe an inch thick. As he stumbled, he did his best to alight on his feet in the bottom of the pit, and he did alight on his feet, but his legs doubled under him. Plaintiff said he had not seen the iron rod before. He saw it from some distance after he was assisted and hobbled out of the hole, not before. He did not examine the rod to see what it was. He only glanced at it after he came out of the hole because he was in excruciating pain at the time. He was not sure whether the rod was something that was used by the Smith Trailer Company. It could have been, but he did not know. As we have seen, the complaint charged negligence of defendant in failing to maintain a barricade around the pit. In plaintiff's brief, it is argued that this was negligence. We shall dispose of this contention after we've discussed the claim of negligence in allowing the rod to lie on the ground. The briefs argue the question whether there was sufficient evidence that defendant was guilty of a breach of duty. Plaintiff argues that it could have been inferred that the rod had been left by workmen of defendant or his subcontractor, since plaintiff testified it had ridges on it and presumably was the type of rod the subcontractor had been removing with the concrete. If this were true, defendant was chargeable with knowledge that the rod was there. If someone else placed the rod there, it could have been inferred that it had been there long enough for the defendant to discover it. The necessary conclusion is that the condition was a dangerous one and defendant was negligent in failing to remove the rod. With respect to defendant's replies to the arguments, it is sufficient to state that it is contended that plaintiff's version of the accident was incredible. The only charge of negligence in the complaint was the failure of defendant to maintain a barricade around the pit, and plaintiff's claim that he stumbled over a steel rod was an afterthought. If plaintiff were walking parallel to the pit, he would not have stumbled into it, and if he did, he would not have landed on his feet. Defendant's witness, Henry Corbin, an employee of the Smith Trailer Company and lead man on the plaintiff's shift, testified that plaintiff received his injuries while he and fellow employees Ralston and Thompson were jumping in the pit from the shallow end into sand toward the deeper end. There was no evidence from which it could be inferred that defendant was responsible for placing the rod on the ground or that he had actual or constructive knowledge of its presence. Plaintiff could not lead one specific act of negligence and recover on proof of another. Okay, space up a little bit. Ready? It was alleged in the complaint that plaintiff was lawfully on the premises, meaning presumably that he was not a trespasser. He says he has always supposed that he was an invitee of Rose, but he has mentioned no fact that would indicate the existence of that relationship. Defendant is accused of only passive negligence consisting of the alleged failure to maintain the portion of the premises he was using in a reasonably safe condition. Whatever duty he had with relation to the condition of the premises arose out of the relationship between himself and the plaintiff. The only theory of the case plaintiff advanced in his briefs was that he was a business invitee. He cited Davis versus Hager Food Stores, which he said is a case exactly in point. In that case, the defendant, operating a food market, was held to a high quantum of care to keep his premises in a safe condition for his customers and chargeable with knowledge of an unsafe condition. For reasons to be stated, we are of the opinion that plaintiff's status was that of a licensee or a trespasser. Defendant was an occupier of that portion of the premises, use of which was necessary for or incidental to the work he was doing for Smith. Plaintiff, as an employee of Smith, was its invitee, but this did not make him an invitee of defendant with respect to the area in and immediately surrounding the pit which defendant was using. They had no business together. Plaintiff's presence in the vicinity of the pit was of no concern to defendant. The washroom was not maintained by defendant and was not under his control. It was not shown that it was necessary for plaintiff, in order to reach the washroom, to walk close to the pit. There was no evidence that he had followed that course before, and no evidence that defendant had ever seen him in the vicinity of the pit. On the day of his alleged injury, plaintiff was on a mission of his own. There was no basis in the evidence for an inference that his presence in this area at any time was invited by Rose. It could be argued with considerable force that plaintiff was not even a licensee, in that it was not shown that he had either expressed or implied permission to walk around the edges of the pit. In view of the nature of the work that he had been doing, reasonable assumption that Rose would have preferred that strangers to the work would remain away from the pit and the area around it, which he was using for deposit of the excavated material. However, inasmuch as plaintiff was not a business invitee, it is immaterial whether the facts would have justified a conclusion that he was a licensee of Rose and not merely a trespasser. Okay, take a look at that. Natasha?
It was alleged in the complaint that plaintiff was lawfully on the premises, meaning presumably that he was not a trespasser. He says he is also, no,
He has
supposed,
always supposed.
that he was an invitee of Rose, but he is.
He has again. Do you use a Z for has ending or?
Sometimes, but I always use stroke.
Yeah.
I always put have.
Okay, but he has mentioned
no fact that would indicate the existence of that relationship. Defendant is accused of negligence.
Only passive negligence.
And passive negligence consisting of the alleged failure to maintain a portion of the premises he was using in a reasonably safe whatever duty.
KN. Do you have KN there?
A bunch of others.
Okay, reasonably safe condition. And then whatever.
Whatever duty he had with relation to the condition of the premises arose out of the relationship between himself and the only theory of the case plaintiff advanced in his briefs that
Was that?
He was
He was a
invitee.
business invitee. Okay, Diana?
We cited Davis versus
Hager.
Food Stores, which he said is a case exactly in point.
In point.
In point, in fact.
And then period. In that case.
Oh, in point. Okay. In that case, the defendant operating a food market was held to a high quantum of care to keep his premises in a safe condition for his customers and chargeable with knowledge of an unsafe condition for reasons to
be stated.
To be stated.
All right, here we go. For the record. It was alleged in the complaint that plaintiff was lawfully on the premises, meaning presumably that he was not a trespasser. He says that he has always supposed that he was an invitee of Rose, but he has mentioned no fact that would indicate the existence of that relationship. Defendant is accused of only passive negligence consisting of the alleged failure to maintain the portion of the premises he was using in a reasonably safe condition. Whatever duty he had with relation to the condition of the premises arose out of the relationship between him and the plaintiff. The only theory of the case plaintiff advanced in his briefs was that he was a business invitee. He cited Davis versus Hager Food Stores, which he said is a case exactly in point. In that case, the defendant, operating a food market, was held to a high quantum of care to keep his premises in a safe condition for his customers and chargeable with knowledge of an unsafe condition. For reasons to be stated, we are of the opinion that plaintiff's status was that of a licensee or a trespasser. Defendant was an occupier of that portion of the premises, use of which was necessary for or incidental to the work he was doing for Smith. Plaintiff, as an employee of Smith, was its invitee, but this did not make him an invitee of defendant with respect to the area in and immediately surrounding the pit which defendant was using. He had no business together. Plaintiff's presence in the vicinity of the pit was of no concern to defendant. The washroom was not maintained by defendant and was not under his control. It was not shown that it was necessary for plaintiff, in order to reach the washroom, to walk close to the pit. There was no evidence that he had followed that course before, and no evidence that defendant had ever seen him in the vicinity of the pit. On the day of his alleged injury, plaintiff was on a mission of his own. There was no basis in the evidence for an inference that his presence in this area at any time was invited by Rose. It could be argued with considerable force that plaintiff was not even a licensee, and that it was not shown that he had either expressed or implied permission to walk around the edges of the pit. In view of the nature of the work that he had been doing and would continue until the pit was completed, it would be a reasonable assumption that Rose would have preferred that strangers to the work would remain away from the pit and the area around it, which he was using for a deposit of the excavated material. However, inasmuch as plaintiff was not a business invitee, it is immaterial whether the facts would have justified a conclusion that he was a licensee of Rose and not merely a trespasser. In general, the possessor of land is not liable to harm to trespassers caused by his failure to put the land in a reasonably safe condition for their reception, or to carry on his activities so as not to endanger them. If the presence of the trespasser is discovered, the possessor is commonly required to exercise reasonable care for his safety as to any active operation possessor may carry on, and possibly as to any highly dangerous conditions on the land. All right, let's see, let's change topics. Also a legal straight matter. Ready? For the record. Now, getting back to immediately after the accident, the fall down the stairs. I will strike that word fall because he didn't fall. He ran down the stairs, you will recall. The only mark that he had on his body was an abrasion on his elbow. There were no bruises. There were no other abrasions. There was no bleeding. He was never hospitalized. There was no cane, no wheelchair, none of the things that you would normally expect to find in someone who sustained a serious injury. He got up, according to his testimony, after the accident and drove to the employer's office. Then he drove to the emergency hospital for x-rays. He returned to work 9 days after the accident and worked for 4.5 months. And while we are talking about work, both doctors seem to be agreed that he could do light work. Yet, he hasn't worked for almost 4 years. Why hasn't he worked in 4 years? No one knows the answer at this time. Now, Mr. Clyde is 62 years old. He has had a job or two here and there. He has worked hard all his life, I am sure. But everybody gets tired and everybody likes to retire. It seems to me that Mr. Clyde took a minor incident here and saw it as a chance to take an early retirement, and that is what he has done. Now, ladies and gentlemen of the jury, when you look 5 times in your 4 years for a job, you are not very serious about finding one, are you? That is slightly more than 1 look for a job per year. How serious could a person be to find employment if for 4 years almost he goes without working and makes 1 effort a year to find gainful employment? He doesn't sound like he really wants to work to me. Remember this, there is no conflict in the evidence as to his ability. Remember this too, these doctors concluded over 3 years ago, back in March of 2011, that he was able to do light work. He didn't recently conclude that. He didn't have to go through any convalescent period. We are talking about 8-10 months after the accident that he was able to do light work. So I think there is a serious question of Mr. Clyde's desire to resume gainful employment. And why should he? He is getting almost as much now without working as he was when he worked, and I think that's important as far as motivation goes to seek employment. Ladies and gentlemen of the jury, there's been some references made by Mr. Salcido referring to items number 3 as a warning. There's no evidence that we ever received any notice of any defect of which one would warn Mr. Clyde. Mr. Jackson made a statement that kind of aggravated me when he said that an inspection might be required every 30 minutes to keep the stairway safe. Don't you notice a similarity between his statements to that effect and the statement of Mr. Clyde that he had gone up that stairway and it was okay 30 minutes before? Don't you think that's a little bit obvious? You know, if you ran up and down those stairs 40 times every 3 or 4 hours, I figured it out someplace this morning. It comes up to something like 640 times during the process. You'd have to employ a full-time man just to run up and down the stairs. I'm not going to comment more on Mr. Jackson's testimony because I think what Mr. Jackson is doing, and he wouldn't even be telling you exactly what he's doing, but he's being paid. At least Dr. Casey had the candor to come out and tell you that he was charging $950 an hour to spend with you in this courtroom. Mr. Jackson wouldn't even tell you that. He did admit he's being paid by the plaintiff, so am I, even going to dignify. I'm not going to dignify his testimony with any further comments. Well, I am going to change my mind because he said a couple of things that I think should be reminded. He did admit that occasionally we have such things as pilot error, that once in a while somebody can actually fall and get hurt even though nobody else is at fault. He did finally concede that. I will give him credit where credit is due. One other thing, Mr. Nair brought out to Mr. Jackson that it wasn't the safest thing in the world for Mr. Clyde to be trying to descend those stairs with all these buckets and these other tools in his hands. He finally admitted that. But that was admitted only grudgingly, ladies and gentlemen of the jury. Now, as far as Mr. Ogden's testimony, the assistant superintendent for Looking Glass, as far as the testimony of Mr. Peterson, look at the testimony, ladies and gentlemen of the jury. You heard and you saw the witnesses, and you are the judge of their credibility. And I submit if there were ever two credible witnesses, those gentlemen were credible. They didn't pull any punches. They said it the way it was. They didn't hedge. They told you that they walked this area every day. That was their job, to look for problems of safety and correct them if they found them. Ladies and gentlemen of the jury, that was their job. They did it every day. So I thank both of these gentlemen. I think their testimony ought to be given a lot of consideration. They were candid in their responses and they pulled no punches. Okay, so I think one of our takes today might have a subject matter of American Disabilities Act. So I have a warm-up congressional on that topic, which most of you have this hard copy from several quarters ago, and I know that it was put on Moodle at one time. It had a bunch of briefs and phrases, American Disabilities Act, and it looked like that. It had all the things written above it. So anyway, that's what I am. That's what I'm dictating from. Okay, ready? For the record, Mr. President, today I will submit a resolution that has been prepared with the help of my distinguished colleagues. This resolution will hopefully serve to reinforce and re-emphasize America's awareness of the needs of the handicapped community. All too often, the needs of the handicapped American are overlooked. They have remained silent for years because their cries for help were ignored. I would like Congress to concentrate on the legislative initiatives that will further assist all disabled Americans. This resolution, along with other legislation, will form the basis for the American Disabilities Act, which will assist all handicapped Americans in their quest to receive equal and fair treatment in the workplace, in the educational environment, and in the privacy of their home. Handicapped Americans are eager to join the mainstream of modern society. Handicapped Americans look forward to the day when they are considered as equals in the workplace. Everyone must agree that finally the time has come to begin to recognize the potential contributions that disabled Americans can make to the growth and development of American business and industry. For years, their valuable input has been overlooked and discouraged. For too long, Americans have emphasized the limitations of disabled individuals. Americans have refused to allow handicapped individuals the opportunity to join the workforce and demonstrate their capabilities. During the past 15 years, we have made great strides in breaking down the barriers that have prevented the disabled individual from circulating freely in today's technologically oriented society. Several programs have been designed to allow the disabled person greater access to public and private buildings, such as wheelchair ramps, braille coding on elevators and buildings, closed captioning on building monitors and television screens, and devices for the hearing impaired to receive messages through specially adapted telephones. Along with this elimination of physical barriers, American industry must learn to use the abilities of the handicapped. Because a person is handicapped does not mean he is unemployable. The intent of my resolution is to make the public more aware of the problems faced by our nation's handicapped Americans. If the public is more aware of the problem, then we know that industry is also more aware. As members of Congress, we are the elected representatives of all segments of society. We should start this term of Congress by encouraging our constituents to integrate the disabled American into the mainstream of society. By proposing legislation that will create employment opportunities, we are not only helping the handicapped American, we are helping society as a whole by allowing all productive members the right to contribute. Mr. President, we have reached a critical point in time. We can no longer avoid the issue. We need to work with the American communities and community leaders to foster a true awareness and better understanding of the obstacles that handicapped Americans must face in everyday life. Through previous legislative initiatives, we have solved some of these problems, but we still need to strive to break down and eliminate certain prejudices about disabled Americans that still exist today. I offer a challenge to each person in this room. One day next week, try blindfolding yourself. Then try to walk down a city street in your area. Try to negotiate curbs and driveways and ramps and traffic and stoplights. Better yet, try managing public transportation. Try to find your way around in a 12-story building. None of these are easy. They are a formidable challenge that many disabled Americans must face every day. Ladies and gentlemen, everyone in this room knows someone who is disabled either at birth or through accident or other hardship. Take a look at that life as if it were your own. How would you manage? How would you cope? By viewing the disabled person and his frustrations, you can come to understand why this resolution is important. I ask for unanimous support of this resolution. We are aware that at this time Congress must appoint a full-time committee to study the problems of the disabled American. Okay, so we'll start takes and do that congressional first when we get started.